Welcome to the Supreme Court of the United Kingdom, where today we are beginning a four-day hearing of appeals in proceedings brought by the Financial Conduct Authority against a number of insurance companies. The proceedings are test cases concerned with business interruption cover in insurance policies. The purpose of the proceedings is to determine what liability, if any, the policies impose on the insurers towards businesses that have been affected by the COVID-19 pandemic. I'm hearing the appeal with four other members of the court, whom I will introduce now. The Deputy President, Lord Hodge.
Good morning.
Lord Briggs. Lord Amlin.
Good morning.
And Lord Leggett.
Good morning.
We are going to be hearing today and tomorrow morning the submissions made on behalf of the insurance companies who are appealing against aspects of the decision of the court below which went against them. The insurance companies are Arch Insurance, Argenta, Hiscox, MS Amlin Underwriting, QBE UK, Royal & Son Alliance, and later in the proceedings we'll also be hearing from Zurich. The first submissions are going to be made by counsel on behalf of QBE. That's Michael Crane, Queen's Counsel. So I'll turn now to Mr. Crane and invite him to open his submissions.
Good morning, my lord. I, as you say, appeared for the fifth appellant, QBE, and before I address the court, may I say on behalf of all parties that we are very grateful to the court for bringing this appeal on with such speed, and we appreciate the burden that must have involved, in particular in relation to late receipt of a massive documentation. So we are grateful for that. Lord, the order of speeches on behalf of insurers will roughly follow the plan of the judgment. That is to say, we will address the so-called disease clauses first before turning to those clauses that involve measures restricting or preventing access or causing an inability to use the premises. I have been allocated from the total time given to insurers 1 hour and 35 minutes to be split between my appeal and responding to Mr. Edelman's appeal. And I intend, if I may, to open my appeal in no longer than 1 hour and 10 minutes. I'll see how it goes and bank what's left for my reply. I should also say that in order to avoid duplication, and because time is tight, there are two issues on which my client's QBE will adopt the submissions of other insurers. The first concerns the role of but-for causation, so-called but-for causation, at law and under the trends clauses in each of the policies, and in particular the implications for those issues of the decision in Oriental Express, Hotels and Generali. Now on this clutch of issues, I will adopt the submissions made on behalf of Amlin by Mr. Healy. The second issue is that described in the written cases as pre-trigger losses. Now, this issue potentially affects all insurers, but it has a more profound impact on those writing restrictions or prevention of cover policies, and it figures very largely in Mr. Edelman's appeal. So I'll say no more about that, other than to say that QBE will adopt Mr. Lockie's submissions made on behalf of ARC. My lord, my appeal is concerned only with so-called disease clauses. QBE is an appellant in relation to a group of 4 policies referred to collectively in the judgment as QBE1, These policies have identical so-called disease clauses, save in one respect, to which I'll refer later. I'm also responding to the FCA's appeal, the Financial Conduct Authority's appeal, against the Divisional Court's construction in QBE's favour of two policy wordings referred to in the judgment as QBE2 and QBE3, respectively. Now, before coming to the QBE1 wording, may I invite the Court's attention to 4 paragraphs of the judgment of the Court below. And the Court will find the judgment in File C. For those with paper documents, it's behind tab 3. And the first paragraph, to which I'd like to refer, is paragraph 81, and that's at page 57 of the electronic file. And paragraph 81 starts at the foot of the page, and it says this: it will be necessary to consider the terms of each of these policies separately, as it is, of course, impossible to determine questions of policy coverage in the abstract. What these policies share, however, are provisions which in broad terms provide coverage in respect of business interruption in consequence of or following or arising from the occurrence of a notifiable disease within a specified radius of the insured premises. And then there follows a sentence which is not that easy to unpack. In relation to each, there arises the question of whether there is cover in respect of a pandemic, where it cannot be said that the key matters which led to business interruption, and in particular the governmental measures, would not have happened even without the occurrence of COVID-19 within the specified radius, as a result of its occurrence or feared occurrence elsewhere. And what we take that to mean is that it can't be said that the loss-causing measures would not have happened had there been no occurrence of COVID-19 within the specified policy area, as those measures were taken as a result of the occurrence or feared occurrence of the disease elsewhere. Now, the next paragraph is paragraph 100, and this is a paragraph with which my clients agree, where the Court says at page 66, while much of the argument was understandably put in terms of the nature of the causal requirements, we consider that what underlies the dispute in relation to causative requirements is a difference as to the nature of the peril insured, and this depends on a proper construction of the relevant terms of, and then it refers to the extension clause in another policy, the disease clause. Once that question of construction is answered, it seems to us that the issues of causation will also largely have been answered, and in particular, it will have been established which matters can be said to be separate, non-insured causes which could be seen as distinct from the insured peril. Lord, we respectfully agree with that. Once the insured peril is correctly identified, and that is purely a matter of policy construction, causation largely answers itself. And once you've identified the insured peril, you know what it is that has to be removed or reversed out for the purpose of the hypothesis demanded by the policy disease trends clauses. The next paragraph is paragraph 110 at page 69, where the Court says, if we are correct in our view as to the nature of the cover provided in the relevant disease clause, not mine, then the issues as to causation largely answer themselves. If properly construed, there is cover for the effects of a disease which may occur both within and outside the specified radius, and which may trigger a response of the authorities and the public to the outbreak as a whole, then it would be inconsistent with the nature of the cover to regard the occurrence of the disease outside the radius or the response of the authorities to that occurrence of disease as being alternative uncovered causes of the business interruption, which could be relied on as supporting an argument that would have been the same business interruption in the absence of the insured peril. And in relation to the trends clauses, this is clearly set out at paragraph 532 at page 179 of the same file. And as I say, this is in relation to trends. Similarly, in relation to the disease clauses, we have concluded that there is cover in principle where we have concluded that there is cover in principle, we have done so because we consider that on the correct construction of these wordings, they ensure the effects of COVID-19 both within the particular radius and outside it. The whole of the disease, both inside and outside the relevant area, has to be stripped out in the counterfactual. So, my Lord, there we are. The court concluded that the insured peril was the disease at large and the measures taken in respect to it. And the last paragraph, before I turn to my wording, is paragraph 540 at page 180 of the file. At paragraph 539, the court has addressed the types of proof which in principle will be available for demonstrating the existence of a case of COVID-19 within a relevant policy area at a given date. And then at 540, they say this: the hearing proceeded accordingly and no expert evidence was heard on the question of prevalence. The court is therefore not in a position to make any findings of fact about the actual prevalence of the disease at particular dates or in particular locations. And my Lord, against that background, can I now turn to my policy wording, which is also, this is QBE1 in file C at page 715. And for those following in paper documents, that's tab 12. And if I can start at page 716, the contents page, your Lordships will see that this policy is a composite policy which covers a miscellany of different risks. And the sections to which I will turn are firstly the core section, section 4, which is the property section, and after that, the section of central relevance, business interruption, which is section 7. But before coming to that, I should say that QBE insures policyholders that fall into 6 out of the 7 categories helpfully identified by the court at paragraph 53 of its judgment. Perhaps we needn't come to this. But if for your Lordship's note, at file C, page 1951 and following, there's a very helpful schedule which tells you what category of clients is insured by any given policy under consideration. But all I'd like to say at this stage is that while QBE does cover, in many cases, policyholders a resident in London and major English cities, it also covers policyholders situated in other parts of the UK, some of them remote parts. For example, QBE has a number of policyholders in the Highlands of Scotland, benefiting from disease clauses. It has 9 in the Orkney Islands. It has 1 in the Isles of Scilly, and it covers insureds in Northern Ireland, in Armagh and Omagh, and in some of the more remote parts of Wales, as well as the major metropolises. I'll come back to the significance of that briefly and in due course. Now, if we go to page 724 of Bundle C, the court will see the property section, and this gives cover for physical damage to insured property. And it's to be assessed, the loss is to be assessed in accordance with the basis of claim provisions. And you'll see that the cover works in relation to accidental damage to property insured. Now, accidental and damage are both defined terms. I'll give you the references to save going to them. The former, accidental, is at page 804, and it means, not surprisingly, a single and unexpected event. The latter, property damage, means physical damage to tangible property, and you'll find that definition at page 807. You'll also see here a reference to territorial limits, and the territorial limits for the property section, and indeed for the business interruption section, before we come to the relevant sublimits, are the United Kingdom generally. And that you'll see at clause 23.110 at page 817, unless the court feels it wants to look at those definitions. I won't spend time going to them. So accidental damage to the property insured is covered, provided that damage occurs during the period of insurance within the territorial limits and from a cause not excluded in the property-related exclusions. Now, against that background, can I come to section 7, which is the section we're centrally concerned with at page 741, which is the business interruption section. And the court will see at 7.1.1 that the core cover for business interruption is business interruption resulting directly from damage as defined to property. Damage has been defined as physical damage to tangible property. And cover is provided for the resulting business interruption, provided that at the time the damage occurs, there's in force either cover under the property section of this policy or, and I'm paraphrasing, a roughly equivalent property cover under a different policy. And then at B, at the time the damage occurs, you have claimed under the policy referred to in A above, and the relevant insurer has either paid such claim or admitted liability or would have paid it, but for the operation of some deductible or excess. Now, there then follows at 7.1.2 basis of settlement provisions, which your lordships will see are applicable to the entire business interruption section. And we needn't, at least for my purposes, flog through these clauses. They're typical of this insurance. They quantify business interruption loss by reference to a number of defined parameters, the relevant ones of which are trend adjusted. And the insured has a choice either to claim loss of insurable gross profit, which in 7.1.2a means the reduction, in respect of reduction of turnover, the sum produced by applying the rate of gross profit, the amount by which the turnover during the indemnity period will, in consequence of the damage, fall short of the standard turnover, which is a trend-adjusted defined term. And again, at 7.1.4, your lordships will see another option, which is to claim reduction in gross revenue. And again, it works by reference to a fairly similar formula, with standard gross revenue being a defined trend-adjusted term. And then, although I don't want to spend time on it because I'm adopting the submissions of others, for your lordships note at page 817, perhaps we ought to go there, actually. Sorry, it's 819, my mistake, I apologise. You'll see the trend clause under the rubric trend adjusted. It's at 23.117. Trend adjusted means adjustments will be made to figures as may be necessary to provide for the trend of the business and for variations in or circumstances affecting the business, either before or after the damage, or which would have affected the business had the damage not occurred, so that the figures thus adjusted will represent as nearly as may be reasonably practicable the results which, but for the damage, would have been obtained during the relative period after the damage. And although that trends clause works by reference to damage as defined, which your lordships know is physical damage, the court found, and it's common ground before this court, that it applies across the board to business interruption caused by perils which are not physical damage. The necessary tweak, if I can put it like that, to the wording being to substitute the insured peril for the word damage when it appears. Can I now come to page 743 of file C, where we see the extensions applicable to the business interruption section, one of which, 7.3.9, and I'll come to that presently, is the disease clause which is central to my appeal. But the stem wording at 7.3 says, we will indemnify you for. And I'll come back to that. It may be relevant to an issue in due course. And there are 3 clauses that I'd like to point up, if I may, en route to the disease clause. Each of these clauses has a specific geographical sublimit which circumscribes the insured peril and limits the risk. The first is a denial of access clause at 7.3.4, which covers loss resulting from interruption of or interference with the business as covered by this section. And here are the words, caused by damage by any cause not excluded by this policy to property within 250 meters of the perimeter of the premises, which physically prevents or hinders the use of the premises or access thereto. And what we say about that and similar clauses is that the specific limit on the territorial scope of the risk is intrinsic to definition of the insured peril. It's only damage within that very narrow confine, which is relevant when you come to ask whether that damage has caused the relevant interference with the business or led to the relevant restriction. The second immediately follows it. It's 7.3.5. It's denial of access non-damage. And this covers loss resulting from interference with the business caused by action by the police authority following danger or disturbance within 250 meters of the premises, which shall prevent or hinder use of the premises or access thereto. Now, a very similar form of wording, namely danger or disturbance within the vicinity of the premises, it was the subject of a decision in the court below. And may I, by analogy, show your lordships where that is to be found. Paragraph 436, it's a number of places, but paragraph 436 of the judgment at 155 of this file. This is one of Amlin's clauses, and AOCA is action of competent authority. And you'll see from the second line of that paragraph that what was in issue were the words following a danger or disturbance in the vicinity of the premises. And I needn't read out that paragraph, but the court found that that connoted incidents within a very narrow compass, in other words, local to the premises, such as a bomb scare or a gas leak. And similar findings, for your lordship's notes, are to be found in relation to the same language, albeit in relation to different policies, at paragraph 466 and 499. So just returning, if I may, to my clause. The inference from the wording used, and indeed from the court below's conclusion on similar wording, is that following danger or disturbance within 250 meters connotes incidents or proximate or local to the premises, and it must be such incidents that cause the relevant loss. And the relevant, the final such clause, which operates by reference to its own specific geographical limits, is 7.3.7 under the rubric loss of attraction, that's 744. And the court will see that that covers loss in consequence of diminution or attraction or of attraction to the premises following damage by any cause not excluded by this policy of property occurring at any other site within a 1 mile radius of any of the premises. So we say that in all 3 of those clauses, the special geographical limits circumscribe the risk and are intrinsic definition of the insured peril. My lord, against that background, can I now focus on 7.3.9, which is the disease clause under consideration in QBE's appeal. And that, if I read back from the stem wording, it's 7.3, that says, we will indemnify you for interruption of or interference with the business arising from, and there are then 5 perils, which A is the relevant one, any human infectious or human contagious disease, excluding AIDS or an AIDS-related condition, an outbreak of which the local authority has stipulated shall be notified to them, manifested by any person whilst in the premises or within a 25-mile radius of it. B, actual or suspected murder, suicide, or sexual assault at the premises. C, injury or illness sustained by any person arising from or traceable to foreign or injurious matter in food or drink provided in the premises. D, vermin or pests in the premises. E, the closing of the whole or part of the premises by order of a competent public authority, consequent upon defect in the drains or other sanitary arrangements at the premises. And then the insurance by this clause shall only apply for the period beginning with the occurrence of the loss and ending not later than 3 months thereafter, during which the results of the business shall be affected in consequence of the damage. My Lords, I make the following points in relation to that clause. First, the stem wording, which you've seen at clause 7.3, tells you this is not, in terms, an indemnity for loss resulting from business interruption. It is cover for business interruption arising from the perils described. And that means that the perils described by the words that follow must be the proximate cause of the business interruption. Now, the court may well be asking, why does it matter whether business interruption is characterized as part of the peril or the loss, which in turn is then quantified by the settlement provisions to which I've referred? To my clause, I'm going to submit that it doesn't matter at all for reasons I'll explain. But the reason flows from the wording of Section 55 of the Marine Insurance Act, which, as the court will know, says that unless the policy otherwise provides, the insurer is liable for any loss proximately caused by a peril insured against, but subject, as aforesaid, he is not liable for any loss which is not proximately caused by a peril insured against. We needn't go to it, but the MIA is at E, page 94, tab 6. What appears to have been suggested is that if business interruption is a component of the peril, then proximate cause only has to be established between the business interruption and the loss, as distinct from business interruption and the damage-causing components of the peril. That's, as I understand it, the potential relevance of the wording, but actually it doesn't matter for my clause, because my clause covers interruption or interference with the business arising from the peril which follows. And it's not, I think, disputed that the expression arising from connotes the relationship of proximate cause between that which immediately precedes it and that which follows. I don't think the FCA disputes that this is the usual significance of the expression. For your Lordship's notes, paragraph 362 of their respondent's case, which can be found, we needn't go to it, at file B, tab 10, page 443. And in any event, it's supported by authority, the most well-known of which is Cox, C-O-X-E, an employer's liability assurance, a judgment of Mr. Justice Scrutton, which the court will find at file F, page 314, tab 19, for those that need it. So I'll assume at the moment that it's common ground that the words arising from connote the nexus of proximate cause between the interruption of or interference with the business, in other words, the words that precede it, and the perils which immediately follow it. So that expression is a pointer to the proximate cause as regards each of those perils. And I should also say, for completeness, that in 2 of the 4 policies comprising QBE1, the words caused by replace arising from. In my submission, they're synonymous. Those policies are at C1566 and C1643, respectively. We needn't go to them. There then follows the description of the insured peril. And there are two clauses that refer back to the noun disease. And these two clauses perform very different roles. The first is purely descriptive. It tells the reader what type of disease qualifies for cover, namely one an outbreak of which the local authority has stipulated shall be notified to them. In effect, it's an internal definition of notifiable disease. The second qualifying clause, however, performs a very different role. These are the words manifested by any person whilst in the premises or within a 25-mile radius of it. This clause tells you what has happened to the disease, how it must have behaved in order to disclose the insured contingency. It must have been manifested by any person whilst in the premises or within a 25-mile radius of it. Manifested by any person whilst in the premises does not supplement the description of the disease. It doesn't add a qualifying characteristic to a disease. It tells you how the disease has acted. It describes a contingency in the nature of an event, and it is that event from which the business interruption must, as a matter of express wording, it's that contingency from which the business interruption must arise. Now, the past participle of the word to manifest has been used by the draftsman, but the same meaning could just as easily have been expressed by use of the present participle, i.e., a notifiable disease manifesting itself in any person. And although it doesn't concern me, your lordships will see an example of that at paragraph 285 of the judgment. It's one of RSA's policies, page 116. Which covers loss as a result of, paragraph 285, closure or restrictions placed on the premises as a result of a notifiable human disease manifesting itself at the premises. So it doesn't matter which tense you use, but what that is describing is something in the nature of a contingency. And it's the contingency from which, as a matter of express wording, the business interruption must arise. Now, in some disease clauses, for example, QBE2 and QBE3, to which we can come later, an occurrence of disease at the premises is covered separately from an occurrence within a radius of 25 miles of the premises. They're treated as separate perils. In fact, perhaps we better look at an example of this so I can make the point. It's at page 97 of the C file. And you'll see in paragraph 208, that's QBE2, which covers loss resulting from interruption or interference with the business in consequence of any of the following events. And A is any occurrence of a notifiable disease at the premises or attributable to food or drink supplied from the premises. And C is any occurrence of a notifiable disease within a radius of 25 miles of the premises. And there are other examples. Now, as I understand it, although this is not an observation made by the FCA in relation to QBE2, but similar clauses. The FCA seems to accept, as regards other disease clauses, that in the case of standalone cover for a notifiable disease occurring in the premises or attributable to food or drink supplied from the premises, an event at the premises has to be the cause of the law. In other words, that must be the causative insured peril. And for your lordship's note, that's paragraph 194 of the respondent FCA's case at B10, page 394. Now, we submit that that is obviously correct, but we also submit that if it's right, there is no reason why cover for an occurrence or manifestation of disease within 25 miles of the premises should not also circumscribe the insured peril from which the BI must arise. It's a different geographical limit, but it has the same role in circumscribing the territorial scope of cover. And all that's happened in QBE1 is that the two separate perils have been elided for the purpose of constituting peril A. Lords, the next point is this: for a disease to become manifest, it has to have been demonstrated either by diagnosis or the showing of symptoms. An occurrence of a disease which is unobservable or asymptomatic cannot qualify. This is common ground, and the court's finding on that is paragraph 225 of the judgment. We needn't look at it, it's common ground. Now, that's an important distinction because the manifestation of the disease by a person is an event in the sense in which that word is commonly used in an insurance context. That is to say, it's something observable which happens at a particular time, in a particular place, in a particular way, and is not too remote from the cause of loss. It's to be distinguished in an insurance context from the remoter causes from which that and other events may have originated. And in making that distinction, we refer in our written case, and I needn't traverse it here, to the familiar authorities cited at paragraphs 74 to 77 of QBE's appellant's case, and that's at B8 277. So once the proximate cause, the relevant contingency, has been identified, you do not search for its remoter origins. The remoter originating cause of an insured contingency is irrelevant. And the authorities in question are the well-known cases of AXA and Field, Becker, Gray and London Assurance, and Everett and London Assurance. And your lordships will find them at those paragraphs. Accordingly, we say the event from which the business interruption must arise is the manifestation of a notifiable disease by someone whilst in the premises or within 25 miles of it. The area limited by the radius operates as a geographical sublimit specific to this risk. It imposes an explicit limit on the scope of the insured peril. In this respect, the radius provision operates similarly to any other territorial limits imposed by a policy. And your lordships have heard that the prima facie limit for business interruption, territorial limit, is the UK. And my lord, that we respectfully submit is the reading, the natural reading of 7.3.9, simply taken on its own. But in its contractual setting, that interpretation is emphasized because, and I needn't label this, the court will see that perils B, C, D, and E are also events which refer to, are also perils, I should say, which refer to events at the premises or attributable to something happening at the premises, namely the provision of food or drink. My lord, can I now deal with the wider matrix? I've dealt with the clause in its contractual setting, at least I hope I have. And I want to make 4 points here because the wider matrix is something on which great emphasis is placed by Mr. Edelman's client. And the first point is this. I apologize if they seem obvious, but I submit they need to be emphasized in the current context. Firstly, it's only information reasonably available to the parties at the time of contracting that is to be attributed to their proxy, the notional reasonable man. We say, for example, that it's reasonable to impute to the broker and underwriters negotiating composite cover of this sort the broad knowledge of public health powers of which the average well-informed citizen would be generally aware. This would include, in serious cases, a power to confine or quarantine infectious individuals, or close perhaps specific premises, possibly even a locality. It's not, however, reasonable to impute to parties negotiating composite cover of this sort the detailed potential implications of public health law outlined at length in the FCA's Respondents text. And most of us, I would venture to submit would have been unaware of those powers before we came to look at this case. So that's point one. Point two, we submit is important. In the vast majority of instances of notifiable disease, the radius clause would operate without undue difficulty to protect an insured business. Before COVID-19 was listed as a notifiable disease, 31 diseases were notifiable under the relevant 2010 public health protection notification regulation. And I wonder if the court would like to look at those. It's in file E. Page 88 is the relevant list of diseases. Tab 5 for those who need it. And what the court will see here is quite a long list. You'll see cholera, food poisoning, Legionnaire's disease, measles, mumps, rubella, SARS, and I'll come to that individually, tetanus and typhus. You'll see quite a few diseases which, if they manifest themselves, are likely to affect a locality, maybe a wide locality, but that would likely be their impact. For example, an outbreak of measles may lead to closure of a school or college.
I'm sorry to interrupt, Mr. Crane, but there was a ruling by the court below, and of course Mr. Crane wasn't involved in the court below, about the incidence of these diseases, because there was a point that arose on ecclesiastical policy, and the court ruled against the FCA's application to adduce evidence on the potential spread of these diseases. So that was ruled out.
Sorry, I'm quite sure whether the direction of that interruption goes, but it's taken a valuable minute of my time. But perhaps I can go on. I don't think anything in the court below.
If you carry on for the moment, Mr. Crane, and then we can hear Mr. Edelman in reply if there is an objection to this line of argument.
Very well, my lord. Can I just say then, for example, obviously Legionnaire's disease might lead to the closure of one or more group of premises, but I'll leave it at that. The converse of this point is that the fact that there are difficulties in applying this clause to the wholly unforeseeable circumstances of this case does not mean that the cover is illusory, a word that you'll come across frequently in the respondent submissions. A year ago, it was utterly inconceivable that the UK and devolved governments would close down almost the entire national economy and confine healthy citizens to their homes to prevent further transmission of a disease. It was inconceivable that such measures would be taken indiscriminately, in the sense of nationally, throughout the UK, irrespective of the prevalence of disease in any given locality. Now, point 3 is that it's not suggested by QBE that an epidemic as such was unforeseeable, as distinct from the extraordinary measures taken in response, in this case, to the pandemic. As the FCA has pointed out, SARS was one of the notifiable diseases, and as a disease such as SARS might well have had unpredictable patterns of transmission and become widespread. But a number of points flow from that. First, it's a fallacy to assume from the fact that a particular risk may have been foreseen as a possibility at the time of contract that the parties agreed to cover it, or, more relevantly, to cover it without relevant limits. The fact that a contingency may have been foreseeable does not mean that the underwriter agreed to cover that contingency without limits, or that the policyholder was willing to pay for such cover. The question whether a given contingency is covered is answered not by asking whether it was reasonably foreseeable to the parties, but by a reading of the insurance clause. Now, the proper inference, the next point, is the proper inference here is that in the face of the risk of a disease occurring with unpredictable patterns of spread, there was no agreement to ensure the effects of such a disease at large. On the contrary, we submit, In the face of such a risk, the parties stipulated for a radius clause, that is to say, for an agreement to cover the impact on an insured business of any such disease manifesting itself within a territorially limited area. Point 4 that I'd like to make on the wider matrix is this: where circumstances have occurred which were inconceivable and contracting. And as I say, it's not the epidemic as such, it's the measures in response. It's tempting to interpret a contract with hindsight so as to make it fit what may seem to be the merits as they now appear. Now, I hope the court will forgive me if I refer in this context to a well-known dictum of Sir Thomas Bingham when he was Master of the Rolls in the case of Phillips Electronic and B-Sky B, which the court will find in file G at page 1556, tab 77 for those that need it. Now this, I should make it clear, was a case about the implication of implied terms, and the court I'm sure will be familiar with it. So one has to treat the observation to which I'm going to refer in that context. But it's found at page 1556, and it's just after the first paragraph break, where the Master of the Rolls said this: the question of whether a term should be implied, and if so what, almost inevitably arises after a crisis has been reached in the performance of the contract. So the court comes to the task of implication with the benefit of hindsight, and it's tempting for the court then to fashion a term which will reflect the merits of the situation as they then appear. Tempting, but wrong. Now, your lordships will see on the previous page, 155, central paragraph, the context for this, which is that the process of implying a term is rather more ambitious than construing a contract, and I want the court to have that context. But it remains relevant because here we're facing the same temptation. We're construing a clause with hindsight in the aftermath, or indeed during a crisis of unprecedented proportions. And there is always a temptation to read it in a way which makes it accommodate the unprecedented facts as they occur. But I have to respectfully submit that that is a wrong approach. My Lord, on radius clauses, before I leave them, the court will have had the core of my submissions when I was going through my clause. But can I just make 5 points in relation to radius clauses before I leave them? The first is this: there's no reason why a radius clause should be treated any differently from any other geographical limit on the risk. The scope of insurance cover we submit is habitually circumscribed by vertical and horizontal limits. And where geographical limits are placed on a risk, the inevitable inference is that instances of the risk occurring outside the geographical area are not covered. That's point 1. And for example, one can illustrate this under the property material damage section of this policy, where the territorial limits of the United Kingdom, that section of the policy would not respond to property damage caused outside the United Kingdom. That would seem obvious, but we say it's just as obvious when you have a sublimit in the shape of a radius clause. The second point is this: geographical limits are simply one method by which insurers limit the potential for accumulation of loss across their book of business. It's a crude tool, but it nevertheless is there for that reason. The third is this: there is no logic, we submit, in the proposition that because the area within the specified circumference is extensive, it is to be inferred that the parties intended to cover the impact of cases outside that area. The fact that the territorial limits on a risk are generously drawn, that the relevant area is nearly 2,000 square miles within a radius of 25 miles from a fixed point, the fact that those limits are generously drawn does not mean they can be disregarded. Thus, a 1 mile, a 5 mile, or a 10-mile radius would reduce the underwriter's exposure, but its effect in circumscribing the risk would in principle be the same. The next point is important. from QBE's point of view, it's a fallacy to view their case as contending for an exclusion of cover if notifiable disease is manifested outside the specified area. Such instances are merely not covered. And in each case, the question is whether the manifestation of disease within the specified area is a proximate cause of the business interference. I need no help from but-for causation in my submission, I should say that. So take a case, the fifth point, where a notifiable disease manifests itself both inside a specified area and outside it. In such a case, a judgment has to be made as to whether the appearance or manifestation of the disease within the perimeter was the efficient or dominant cause of loss. This is a question of fact in each case. If, for example, there is a cluster of cases within the radius, but relatively few outside, the inference might well be drawn that measures taken in response were in response to disease within the insured area. Lord Leggett.
You said the efficient or dominant cause of loss, Mr. Crane. I just wanted to pick you up on that. It's well established nowadays, isn't it, that there can be multiple causes of loss. We're not limited to finding the dominant cause.
That's correct, my lord. If I may, well, I'm going to deal with that in a second, but I'm going to come back to it in relation to the court's view on causation. But in a case where there is disease manifested both inside and outside the relevant area, one has to make a judgment as to whether the causes or the manifestation of disease within the relevant perimeter were the effective cause of loss in the sense that the business interruption arose from those cases. Now,
was that an effective cause of loss? Yeah?
Yes, indeed, an effective cause of loss.
Even if the occurrence outside the zone was another effective cause of loss.
Yes, I accept that. But we'll see on the facts of this case that the relevant measures, there's no evidence that the relevant measures, the government measures which caused the business interruption either from the 16th of March or the 23rd of March or the 26th, were measures in response to the manifestation of disease in any given locality. So one has to ask, in cases where there is disease both within and without the relevant insured perimeter, what are the respective contributions of those cases to the business interruption of the insured premises in question? So I accept, indeed, it's part of my submission that when cases occur both inside and outside the relevant perimeter, it will be necessary to assess the respective efficiency as a cause of loss of the covered and non-covered causes. Now, can I now turn to the Divisional Court's construction? The Divisional Court opted for a construction that removed any causative relevance from a manifestation of disease within the specified area. That's my core complaint, respectfully made. It concluded that the insured peril was the notifiable disease at large, and that cover under the QBE1 disease clause was triggered if and when there was a single manifestation of disease within the defined area. And this interpretation is most starkly illustrated by the Divisional Court's declaration in relation to QBE, which the court will find at page 20 of File C, behind tab 1 for those that need it. .3 is the relevant declaration, and it says this: if COVID-19 was manifested at or within a 25-mile radius of the insured business, as to which see Declaration 7, which, by the way, just tells us the meaning of manifested, there will be cover under the disease clause in QBE1 from the date COVID-19 was manifested in the 25-mile radius, the losses caused by interruption of or interference with the insured businesses caused by COVID, and then it refers to various measures pleaded by Financial Conduct Authority. And then under Roman numerals 1, and this is important, it's not necessary for the interruption of or interference with the insured business to have been caused by the manifestation of COVID-19 within the 25-mile radius, as distinct from its manifestation outside the radius. And 2, the correct counterfactual is as set out in Declaration 11, and just for the court's note, that deals with the trends clause. And of course, once you've identified the insured peril as the disease generally, and measures taken generally with regard to it, you extract that in constructing the hypothesis required by the trends clause. So this means, and I'll just take, this is your hypothesis. This means, for example, that in remote areas of the United Kingdom, such as, for example, the Highlands, the Orkneys, remoter parts of Northern Ireland, or the Isles of Scilly is an example that's been taken before. It's immaterial in such areas whether the lockdown and the consequent interference with local businesses preceded the first recorded case of COVID-19 or not. On the court's construction, it simply doesn't matter whether the first local manifestation precedes or follows the measures that cause the damage. Where the first local case follows, the fiction, and this is advanced by the FCA in their Respondents case, is that somehow that local case operates as a concurrent cause of the continuing loss, to which we say that cannot be correct. It's a fiction. The cause of loss is government measures which on this hypothesis have already had and continue to have their impact. So in short, what on a natural reading in my submission is the insured event becomes, on the court's interpretation, a mere proviso to cover. The radius provision becomes a tick box, cover in sets when someone with symptoms strays into the specified area, presumably with the insured being oblivious to that fact and to the fact that its loss has now become recoverable and the indemnity period, which dates from the date of loss, has now incepted. Now, my lord, against that reasoning, can I come to the one paragraph in the judgment in which the court deals with this clause, or with its interpretation? That's paragraph 226 at page 102. For the court's note, you'll see in 224 that there is a conclusion on the meaning of manifested, with which we respectfully agree. And at 226, we have the court's reasoning. Focusing on the language and structure of 739, we consider that within the insured peril, the required causal link arising from is between the interruption or interference with the business on the one hand and the notifiable disease on the other, provided it has been manifested by a person within the 25-mile radius. We do not consider that the clause most naturally reads or should be construed as saying that the interference has to result from the particular cases in which the disease is manifested within the 25-mile radius. Instead, the cover is for the effects of a notifiable disease if it has been manifested within the 25-mile radius. This appears to us to be apparent from the juxtaposition of the phrase relating to business interruption with that relating to notifiable disease, and the fact that the phrase manifested by any person whilst in the premises or within the 25-mile radius of it is most naturally read as an adjectival clause limiting the class of notifiable disease, which, if they interfere with the business, will lead to coverage. Now, my lord, in my respectful submission, there are 3 errors in this paragraph. The first is that the required causal link arising from is not within the insured peril. It's between the business interruption and the insured peril that follows. And your lordship has had, I hope, a brief but helpful explanation earlier as to why that might matter, because causal relationships within the insured peril don't have to observe the discipline of proximate cause required by Section 55 of the Marine Insurance Act as regards the relationship of the peril to the loss. But in my case, while we say that's an error, it's not an error that matters for reasons I've already explained, namely that it's common ground that the words arising from usually connote proximate cause, the nexus of proximate cause, and that is the only nexus apparent between the business interruption and the various perils that follow. So it doesn't make any difference. However, the other two errors in my respectful submission do. The second is the court says that the reading that you have just heard is the most natural reading. In other words, the reading which I have offered to the court is not the most natural reading. Now, I would respectfully submit that one can test that by asking this rhetorical question. If any of us had read this clause a year ago and been asked what it meant and what it covered, in my submission, the result would have been obvious. It's quite clear that this clause intended to cover the effects of a notifiable disease manifesting itself within the premises or specified area. And the third error in my submission is the court's treatment of the relative clause manifested by any person within the premises or within a 25-mile radius of it. This clause is not a supplement to the description of the disease. That's already been described. It's a clause which tells you, albeit succinctly, what the disease has done, what has happened to it. In other words, it describes a contingency. And it's that contingency which, when one refers back, has to be the cause of the business interruption or loss. So it's easy to say it's adjectival because ultimately it conditions a noun, but actually it's doing a job completely differently from the clause. So, my lord, that's my case on construction. Can I just invite the court to see where the court goes on causation? And we find that at page 69 of file C, paragraph 111. I think we've been there already. No, we haven't. Yes, paragraph 111. We can pick it up, I think, halfway down that paragraph. The first part of the paragraph is dealing with the meaning of the word following. But the court says this halfway down 111, even if the word following imports the requirement of proximate cause, we would consider that given the nature of the cover as we consider it to be, this is to be regarded as satisfied in a case in which there is a national response to the widespread outbreak of a disease. In such a case, we consider that the right way to analyze the matter is that the proximate cause of the business interruption is the notifiable disease of which the individual outbreaks form indivisible parts. So that's, once you've identified the disease at large as peril, it follows that anything caused by the peril at large, provided it proximately affects the business interruption, is recoverable, and by parity of reasoning, it's removed for the purpose of performing the hypothesis or constructing the hypothesis required by the Trends clause. And we should pick up in 112 the alternative view of causation, which the court regards as less satisfactory. And this really is relevant to Lord Leggett's question. each of the individual occurrences was a separate but effective cause. And on this analysis, they were all equally effective because the authorities acted on a national level. Now, I needn't say any more about the court's preferred view of causation because it's completely contingent on who's right as to construction. But if I'm right on construction, there is no problem as to causation, and we can see that in the way the court dealt with QBE 2 and 3 at paragraph 235. Page 104. And the background is the court found for QBE on this wording. They said, given our construction of 3.2.4, the issues as to causation largely answer themselves. Now, I needn't read that paragraph because the court goes on to say how causation works on that hypothesis. Yes, Lord Hammond.
But why is that, Mr. Crane? If paragraph 112 is right, and each local occurrence is an effective cause of the national measures taken, why isn't the local occurrence a proximate cause?
Because, my lord, in relation to 3.2.4, the court has found that the peril is the event constituted by the occurrence of disease within the relevant radius. Ergo, on that hypothesis that construction is right, it follows that those occurrences have to be proven to be the cause of the relevant business interruption. And elsewhere, it's become, in my submission, plain that no cluster or single case of a local occurrence was the cause of the measures which affected businesses throughout the United Kingdom.
But if it was a cause, with paragraph 1125, why isn't that good enough?
Well, my lord, for this reason, paragraph 112 proceeds, and the court regards it as less satisfactory, on the basis that each case of illness is a separate occurrence. And given that that is the case, and we're not talking about interdependent causes here, we're talking about independent separate causes. What has to be demonstrated on that hypothesis is that the independent cases of illness manifested or occurring within a given radius led to or caused the business interruption in question. And on that basis, one is into cases such as the Miss JJ and Wayne Tank and Pump, which concern interdependent causes, which these are not, but which are authority for the proposition, which again has been accepted by the Financial Conduct Authority, that where you have non-covered causes and covered causes, the insured can recover if the covered and non-covered clauses are roughly of equal efficiency. That's accepted as the result of those authorities by the FCA, and I'll give you the paragraph in their case. It's paragraph 347, and it's at tab 10 of B at 439. So the insured will only recover if the insured and non-insured perils are of roughly equal efficiency as a cause of loss. That's what's accepted by the FCA in my submission correctly. Now, on the hypothesis of this, on the assumption of this alternative view of causation, where each individual case is an independent cause, one has to ask whether the combined effect of those causes within the relevant area is of roughly equal efficiency as a cause of loss as the effect of cases outside the area nationally, which prompted the relevant measures. So the question becomes, were the individual cases within any insured area the efficient or proximate cause of the loss? Well, that's an hour and 10 minutes, including 1 minute that Mr. Edelman borrowed from me. Unless your lordships have any questions which I can help at this stage, I would give way to the next insurer.
Well, thank you very much, Mr. Crane. I believe we turn next to Mr. Simon Salzido, Queen's Counsel, on behalf of Argenta.
Thank you very much, my lord. If it's convenient to your lordships, I will first introduce the Argenta 1 wording, then make further submissions on each of my 6 grounds of appeal in order. As your lordships know, time is very short for the oral argument, so it is not a mere formality when I say that I also adopt my written case. I adopt the submissions of Mr. Crane in relation to disease causes generally, and that includes his adoption of the submissions of other insurers on certain aspects. My lords, the Argenta wording is at C tab 5, page 259. And if we turn to page 261, you can see the contents page. And like Mr. Crane's composite QBE1, this is also could be called a composite insurance. The main sections are buildings insurance, the 4th line of the contents, and contents insurance. There are then numerous added extras to those property classes, including business interruption insurance section starting at page 55. And in our bundle, that's C5314. As you can see at the top of the page, 314, the business interruption section is operative only if the contents section is operative, so it never stands alone. On the next page, 315, the main business interruption insurance section. If business at the premises is interrupted as a result of the premises being made uninhabitable by any capital D damage insurable under business or contents section, Argenta will indemnify the insured for the amount of loss stated in basis of settlement up to the limits of liability. Notice, my lords, that the phrase business interruption does not feature in the main BI insuring clause at all, other than in the heading. The closest thing in the text is the word interrupted, which is not a defined term. What then is the structure of the main BI clause? I submit the structure is this. The subject matter of the insurance is the capital B business at the capital P premises. That is the thing that may get damaged by a peril. It's the equivalent of the property or the contents insured under the main section. The policyholder's insurable interest in that subject matter is their entitlement to profits from the capital B business at the capital P premises. The type of damage to that subject matter which this insurance covers is being interrupted. It's the capital B business being interrupted which is the equivalent of property being lost or damaged. The peril which is insured against is the premises being made uninhabitable by capital D damage insurable under the buildings or contents section. That's the fortuity that might cause damage to the business in the form of interruption. As you would expect, the clause specifies a causal link between peril and damage with the words as a result of. The measure of indemnity for interruption damage is defined in the basis of settlement clause. If we look now at the basis of settlement clause at page C5318, again we find that interruption and interrupted are not mentioned in this clause at all other than in the heading. The principal measure of indemnified loss in A of this clause is the amount by which gross income is reduced due to the capital D damage. And that confirms that the essence of the peril is capital D damage. The words due to express the causal link directly from peril to loss. We don't need to look, I think, at the other two. Similarly, my lords, if you go to page C5314, turning back a couple of pages, and see the definition of indemnity period, again, interruption is not mentioned, and the indemnity period makes sense only on the basis that capital D damage is the insured peril. On the same page, you find the definition of standard gross income, which is the Argenta trends clause, and it also makes no reference to interruption, and it also treats capital D damage as the peril which causes the reduction in gross income. My lords, the extensions to the BI cover are at page C5316. The heading at 316 is Business Interruption Insurance Section Extensions. So this is expressly stated to be a set of extensions to the main cover which I have just shown you. You can see the extended insuring clause in the top left box on 316. The company will also indemnify the insured as provided in the insurance of this section for such interruption as a result of, and then the list of extended perils. The word also further confirms that this must be read with the main BI section as an extension of it, and so do the words as provided in the insurance of this section. The term such interruption is a reference back to the main BI insuring clause, and it means interruption of the business at the premises. Again, though, the word interruption is not here a defined or technical term. The phrase indemnify for such interruption confirms that, as we've seen in the main BI clause, such interruption is the type of damage for which the insurance provides indemnity. The words as a result of at the end of the insuring clause are causal words. So one would expect that what follows that phrase will be the insured perils under the extension. And as expected, what follows is a list of perils, whose role in the extension section is identical to the role in the main BI section of capital D damage. It's common ground among Argenta, the FCA, and the Divisional Court judgment that for the purposes of the extensions, in the definitions that I've shown you of basis of settlement and standard gross income, where the word capital D damage appears, it means the relevant peril insured, including under the extensions where they are not damage. And I add, my lords, that the same must be true of the indemnity period definition. It follows from simply reading the policy with its proper structure that the only way to make sense of the wording is the analysis that I have been setting out as I've read it, namely that in the main BI section, the peril insured is capital D damage, which makes the premises uninhabitable, and in the extensions, the peril is the content of each of the boxes on the left-hand side on pages 316 and 317. My lords, looking at those boxes now in slightly more detail, you can see that each is closely focused on the capital P premises, each in its own different way. So in box 1, we have damage to property in the vicinity which prevents or hinders use or access to the premises. Box 2 is damage to utilities supplying the insured. Since the damage has to interrupt the business at the premises, in practice that means damage to a utility that supplies the insured's capital P premises. Box 3 is similar in relation to other suppliers. Box 4, going on to page 317, covers 5 sub-paragraph perils. A, restriction on the use of the premises by order of public authority consequent upon certain matters, all of which have to occur at the premises. B, any occurrence of, note that phrase, a notifiable disease at the premises or attributable to food and drink supplied from the premises. C, a discovery of an organism at the premises. I'll come back to D, which is the important one, in a moment. E, any occurrence of, that phrase again, murder or suicide at the premises. 5, I'll also come back to in a moment. And then 6, damage to property in the vicinity, which deters potential customers. And then just going back, we have the 2 provisions which have a 25-mile radius requirement. Extension 5 is a pollution or an oil spill within 25 miles. And note that the maximum indemnity for that one is a mere £2,500. And 4D is any occurrence of notifiable human disease within 25 miles with 25 miles of the premises with a limit of £25,000. Now, my lords, every single one of these extended perils will have some underlying cause which could itself be the cause of additional loss to the policyholder. Looking at each type of peril broadly, first, we've got damage to property. Well, that could easily form part of a wider issue. There might be a major flood or a severe weather event. Secondly, vermin and pests. They never come single spies. I won't quite submit, my lords, that in London you are never more than 6 feet from a rat, but if you do see a rat or a mouse or a cockroach, you can be pretty sure that you are not far from many, many more of them, some of which may be at the premises, some of which may not be, and there may be a common cause to any given infestation. Diseases similarly occur in outbreaks, as the FCA emphasises many times in its case. Even a murder at the premises could be part of a campaign of terrorism, which could lead to action by the authorities, leading to business interruption. And oil spills have been known to pollute not just 25 miles area, but thousands of miles of coastline length in the worst cases. And my lords, we accept that essential facts of nature of that kind may be taken to be known by the parties. And with that knowledge, the parties to this contract agreed to draw particular lines on the causal chains that might lead from those underlying causes to loss. And the lines are the ones set out in the boxes on page 316 and 317. Indeed, one could say that that's fundamentally what insured perils are. They're the agreed stopping points on the legal causal chain that must be traced through the complex net of factual issues and factual causes. In any insurance, the insured will normally benefit from drawing that line further back from the loss so as to have more available routes of recovery. The insurer will benefit from drawing that line closer to the loss so that there are less available routes factually of recovery. That is one of the key matters that any insurance wording will resolve. And of course, it may well have an impact on the price of the cover because it's a key matter going to the risk. One further part of the wording to notice on page C5317 in the right-hand box contains the section exclusions to box number 4, and section exclusion Roman 3 is for any loss arising from those premises that are not directly affected by the occurrence, discovery or accident. And what I draw attention to in that exclusion is the phrase, the occurrence, discovery or accident, which words are strongly redolent of specific and discrete events of the sort listed in box 4. So, my lords, just stopping to take the words literally at this stage, what extension 4D actually says is that there is indemnity for interruption to the business at the premises as a result of any occurrence of a notifiable disease within 25 miles of the premises. This is therefore cover for damage with the small d, the form of which is interruption to the capital B business at the capital B premises, only when caused by the peril or fortuity of any occurrence of a notifiable disease within 25 miles of the premises. That's what it actually says. Now, my lords, the bulk of the business interruption losses with which this case is concerned were immediately caused by government or public responses to COVID-19. The underlying cause was the pandemic itself. As Mr. Crane showed you, the judgment of paragraph 81, which if you want to look at it again is at C3, page 57, points out that the question that arises on disease clauses is whether there is cover in respect of a pandemic where it cannot be said that the key matters which led to business interruption, and in particular the governmental measures, would not have happened even without the occurrence of COVID-19 within the specified radius. That is the question. There are some attempts by the FCA perhaps to suggest differently on this appeal. But my lords, if an individual insured can prove that their losses were caused by occurrences within the radius, then Argenta has never denied cover. That's never been part of the dispute between Argenta and its policyholders. This test case concerns whether or not that is one of the things that has to be proved. The effect of the judgment is that that is one of the things that does not have to be proved. So the central question on Argenta's appeal is whether there's cover under Extension 4D in a case where the insured peril, as defined in Section 4D, does not feature on the causal chain leading to the relevant losses. And Argenta submits that once one reads the policy and identifies the question, with all respect to the court below, it is obvious that there can be no such cover. My lords, my 6 grounds. Ground 1 is the identification of the peril and what counts as damage and loss. And I've obviously, in a sense, made submissions about this as I've shown you the policy. Ground 1 is that the court below was wrong to identify the relevant peril in Argenta 1 as being a composite of business interruption at the premises as a result of Extension 4D. That's to say, bringing business interruption into the peril itself. At the trial, the precise identification of the peril in Argenta 1 as being any occurrence of a notifiable disease within 25 miles of the premises was common ground. Argenta pointed that out in writing and orally and was never questioned or contradicted on it. The court overrode that common ground without acknowledgement or explanation. Even on this appeal, my lords, it remains common ground that the words "as a result of" denote proximate causation in Argenta 1, and I'll come back to show you that shortly. On our view of the peril, those words at page C5316 appear between the peril and the damage, which is exactly what you would expect. But on the Divisional Court's analysis and the FCA's case, they are an anomaly. Our analysis is also consistent with the fact that the wording does not state any causal connection between such interruption and loss. And my lords, the FCA notes this point in its respondent's written case at B10403. I could just ask your lordships to look at that at paragraph 224.2. And at 224.2, your lordships see the FCA write, Argenta unusually does not include a provision indemnifying for loss resulting from the interruption. It does not specify a causal link between loss and interruption at all. It just provides an indemnity for the interruption. This most likely imports the default proximate cause test between loss and the interruption. So the FCA is driven to argue that the lack of any causal link most likely imports proximate cause. In our submission, that involves strain and artificiality. The natural construction of the words used at C5316 is that the indemnity is for the small d damage, which is constituted by such interruption of the capital B business. That construction does not invoke causation at all, which is consistent with the absence of causal wording between those two matters. I also refer, my lords, on this point to our written case at B5124, at paragraphs 27 to 28, where your lordships may recall that we have referred to some authorities showing the way that peril has always been understood in insurance law, including, of course, Section 55, which Mr. Crane has already read to my lords. And we spell out at paragraph 28 the analogy between other forms of sort of more basic insurance, if you like, and business interruption cover. My lords, what we say about this is also entirely consistent with the history of business interruption cover, which the FCA has set out in its written case at B10, page 361. And your lordships may recall that at paragraphs 93 to 95, the FCA set out that the origin of business interruption cover was to permit the recovery of consequential losses from property damage. There have been authorities saying that was not covered, and indeed in Argenta it's expressly stated that consequential loss is not covered. That's at page C5353. We don't need to go to it. So in other words, business interruption started not as a peril, but as a form of damage involving consequential loss, which was not recoverable in the property section. It was made recoverable by making capital D damage into a peril which was then insured against under the business interruption section. The later edition, historically later, of non-damage extensions didn't change the analysis. All it meant was that damage in the form of business interruption was indemnified if it was caused either by the originally defined peril, capital D damage, or one of the new non-damage extended perils. My lords, on this issue of what counts as the peril, the judgment contains no reasoning, only conclusions. So there's nothing for me to take you to in the judgment. The weak support given to the judgment by the FCA's respondents' written case at B10401, paragraph 218, where they talk about the provisions of some policies that may have a causal link between business interruption and loss. That, of course, does not apply to Argenta at all. The points that are made against Argenta are at paragraphs 219 and 220. And your lordships, I'm not going to take time now, but when your lordships remind yourselves of paragraph 219 and 220, you'll see that they are purely to the effect that the issue does not ultimately matter. As to whether the issue doesn't matter, your lordships were shown by Mr. Crane paragraph 100 of the judgment, which shows that the divisional court certainly thought that it mattered, indeed thought that it was critical. So it clearly did matter to their decision, even if it should not have done. So, my lords, ground one of our appeal should succeed, because the words of Argenta 1 correspond precisely to the orthodox analysis we have set out. There's no reasoning before your lordships from the court below to suggest a contrary answer, and there's no reasoning from the FCA either that could support any different result. So, my lords, we say ground one should succeed. My second ground is that the court wrongly concluded that the words "as a result of" in Argenta's business interruption extension did not require proximate cause. Now, my lords, in the introductory part of the respondent's written case, at B10 page 346, paragraph 31, the FCA appears to adopt the view that we criticise on this point, but in the light of what I'm about to say, it seems that what they say there is not intended to apply to Argenta. None of the individual judgment paragraphs they cite at 31 relate directly to Argenta. And later in the written case, when the FCA deals with Argenta specifically, at B10401, where we were just before, at paragraph 219, which I was referring to on a slightly different point a moment ago, they say that, if you look at paragraph 219, going over onto page 402, the FCA says, we have misunderstood the judgment on this point. They say that where the term is resulting from, the FCA accepts this requires a proximate cause test. They say there's no dispute on this point and Argenta is aiming at the wrong target. My lords, I assume that when they say resulting from, they mean as a result of, which are Argenta's words. And the point is also made explicitly in relation to Argenta, again in the FCA case at B10443, paragraphs 361 to 362. So it seems from those paragraphs as if it is expressly and clearly common ground on this appeal that the words as a result of mean proximately caused by. Now, my lords, I maintain my submission that the divisional court got this point wrong as well, for all the reasons given in our written case at paragraphs 42 to 46. But given the time constraints, I will assume that your lordships will accept what is put before them as common ground on this appeal, and I will not spend further time on it. But my lords, whether because we are right to criticise the judges below in ground two, or whether because it's now common ground, in either event, your lordships should hold that as a result of, in the Argenta wording, are words of proximate causation. So on that basis, it follows that what Argenta 1 actually says is 1, it indemnifies for, 2, business interruption, 3, proximately caused by, 4, any occurrence of a notifiable disease within a radius of 25 miles of the premises. As the court below acknowledged at paragraph 81, which, as I say, you've seen before, it has not been shown in this test case that occurrences within the radius of any particular Argenta policyholder caused the governmental measures which caused most of their losses. And that's enough to establish that it has not been shown that the actual words of Argenta 1 are satisfied by the generality of claims for COVID-19 losses. The remaining question is whether there's any basis to read the policy as meaning something different from what it actually says. And that takes me to ground 3. Ground 3, my lords, is that the court wrongly distinguished Argenta 1 from QBE 2 and 3, which it had found were not triggered by most COVID clauses. Like ground 1, ground 3 of our appeal relates to a point that was not argued at trial. Nobody suggested that the points that the court found made QBE 2 and 3 different were relevant points. So we never had the opportunity to address this either, as well as to address ground 1. The court was, of course, right to hold that QBE 2 and 3 did not provide cover, but it was wrong to distinguish Argenta 1 from them. My lords, if you go to C13852, you can see the operative words of QBE 2 at paragraph 3.2.4c. And they are loss resulting from interruption or interference with the business in consequence of any of the following events. C, any occurrence of a notifiable disease within a radius of 25 miles of the premises. Now, at first sight, that's rather similar to the clause I've been showing you at some length in Argenta. What's the difference? The answer is given in the judgment at C3103, at paragraphs 231 and 232. And the judges below found two differences. At paragraph 231, which I think you have seen already, the point that is being made is that the words "the following events" at the top in the stem at 3.2.4 of QBE2 show that what's insured under A to F are matters occurring at a particular time in a particular place and in a particular way. And that relates to the AXA Reinsurance Authority about the meaning of the word event. And in particular, what their lordships say in the last 8 lines of paragraph 231 is this. They say, given the reference to events and taken with the nature of the other matters referred to in A, B, and D to F, the emphasis in C appears to us in this clause not to be on the fact that the disease has occurred within 25 miles, but on the particular occurrences of the disease within 25 miles. It's the event which is constituted by the occurrences of the disease within the 25-mile radius, which must have caused the business interruption or interference. If there were occurrences of the disease at different times and or different places, these would not constitute the same event, and the clause provides no cover for interruption or interference with the business caused by such distinct events. The court thus rightly accepted 2 points upon which I rely. First, the other matters in the list of extended perils are relevant to the construction of the individual sub-peril with which we're concerned. And secondly, event and occurrence are at the very least capable of being used in the same sense as each other. There's no problem with an occurrence being an event. If we return now to the Argenta wording at C5317, this is also a list of events in the sense in which that word was used by the court below. A is a closure or restriction on the premises. That must be an event at a particular time and place. B, any occurrence of a notifiable disease at the premises or attributable to food and drink supplied from the premises, plainly an event at a particular time and place occurring in a particular way. C, a discovery of an organism likely to result in a notifiable disease, plainly an individual event. We'll leave D till last, come back, look at E. Any occurrence again, but this time it can only be an event in the sense used in the judgment because it's a murder or suicide at the premises. And then going back to D, we have the third use in this list of 5 of any occurrence, and read in context, it's plain that this kind of any occurrence is an event in the same sense. My lords, in our written case at B5, page 143, paragraph 81, we have cited some authorities supporting the view that occurrence is usually used in the sense of event, And on the next page at paragraph 82, we've referred to the primary meaning of the word occurrence from the Oxford English Dictionary. So we say that the natural reading of occurrence in this context is the same in our policy as it is in QBE2. The second difference identified by their lordships below is in the judgment at C3103, page 232, where their lordships say that QBE2 states that the insurer shall only be liable for loss at those premises which are directly subject to the incident. And they find that the word incident further emphasises the focus of the clause. Now, I've already shown you, my lord, that the equivalent provision in Argenta at C5317 refers to occurrence, discovery, or accident. That's the exclusion on the right, which gives exactly the same emphasis in my respectful submission. And in any event, if these words incident and event are really the magic word that unlock the obvious construction, they are used in Argenta 1 to cover generally the insured perils under the policy. If you go to C5349, this is in Argenta, near the beginning of the policy. Sorry, it's not near the beginning, I'm wrong, near the end. 349, part of the general conditions, you'll see that general condition 16.2 and 17.1 both refer to incidents in a way which simply means a matter that might trigger cover. It means a peril under the policy. And for the word event, your lordships can find that in the Argenta policy, right near the beginning at page C5265. In the first line, when an event occurs that may give rise to a claim, you should contact your broker. And at page 270, in the top paragraph, definition of excess, the amount that will be deducted from the total agreed amount of any claim. Only one excess will be deducted from the total amount for claims arising out of one event, using the word event, and then turning back to the end of the policy at page C5350, in the general conditions under the Contract Rights of Third Parties Act condition, if your lordships go to paragraph 2, subparagraph 4, up to and at the time of the occurrence of any event which is the subject of any claim under this policy, the person claiming shall have observed fully the conditions, etc. So if those are the magic words, my lords, we have them. But my lords, we don't make our submission on the basis of magic words, as the court below appeared to make its finding. The fundamental issue is, what would a reasonable business person understand by the term any occurrence of a notifiable disease within a radius of 25 miles of the premises in the context of this policy? And the answer, we say, is, again with respect, rather obvious. Any occurrence indicates a single event. And you can see that what you might call the unities of the reinsurance kind of event are all present here. If you look in the judgment at C384, paragraph 158, your lordship see 4 lines down. Further, it is common ground between the FCA and Argenta that an occurrence of COVID-19 for the purposes of extension 4D requires there to be at least one person within the relevant 25-mile zone on the relevant date who's contracted COVID-19 such that it's diagnosable, whether or not it's been verified by medical testing and whether or not it's symptomatic. So there's never been any dispute about what is the nature of the occurrence, and it is an event. The place where the event takes place, of course, is expressly stated to be within 25-mile radius of the premises. And the time when a person contracts COVID or comes into the area already having COVID is obviously a particular time. So all the characteristics of an event, as the divisional court used that term, are clearly met. And my lords, this is a convenient point to mention an argument that has surfaced in the FCA's Respondents case in several places, which is that because we accept there could be more than one occurrence, it follows that this becomes an insurance for an outbreak of a disease, including an outbreak that exists both within and without the 25-mile radius. And that argument involves a fallacy which is really a jagged fault line running all the way through the FCA's case, which is the confusion between, on the one hand, situations that include the insured peril, and on the other, situations that constitute the insured peril. And to illustrate the point, perhaps we can look at extension 4B at C5, page 317, which is the includes the supply of food and drink from the premises. So imagine, my lords, that some supply of food and drink from the premises leads one or more customers to contract cholera, which you saw earlier is a notifiable disease. What constitutes the insured peril is each occurrence of cholera that is attributable to the supply from the premises. It does not matter whether there is one or more than one such occurrence. If they cause damage to the business, there's cover for that. Now imagine it's discovered that the underlying cause of the problem was an infection in the mains water supply of the whole region. It may then turn out that there was a wider outbreak of cholera, which included occurrences attributable to supply from the premises and also included other cases. Extension 4B still ensures the consequences of the cases which constitute the peril. It does not ensure the consequences of the whole regional outbreak, even though they include the occurrences that form the peril. Now, the FCA's response to that answer is what they call the jigsaw, or the indivisible cause argument, which is the subject of Argenta's ground 4. So, my lords, the indivisible cause, perhaps we should just see it where the court has actually declared the existence of this thing, which is in Bundle C, tab 1, page 6. In relation to Argenta, you see near the top of page 6, Declaration 10. In Argenta 1 and other policies, the occurrence of a case of COVID within a relevant policy area is to be treated as part of one indivisible cause, namely the national COVID-19 outbreak and the governmental and public reaction of any business interruption. Alternatively, and of course this would take us to ground 5, each such occurrence to be treated as a separate but effective cause of national action and any subsequent business interruption. Now, my lords, apart from this case, the combined might of the FCA's legal team has not been able to unearth one single case or text authority anywhere in the whole world where the metaphor of a jigsaw or the analysis of a part of an indivisible cause has been applied to any form of causation, not just insurance law. And that's because these phrases are euphemisms, they are fig leaves for overriding all previous concepts of legal, effective, or proximate causation. The two metaphors, which are used interchangeably by the FCA, are not even compatible with each other, because a jigsaw obviously is divisible into its parts. It's the essence of a jigsaw. If the policy insures one piece of a jigsaw, and it turns out later that that piece which was insured is part of a jigsaw, it does not follow that the whole jigsaw is what was insured. That is simply wishful thinking after the full picture is revealed, contrary to the dictum of Sir Thomas Bingham, which your lordships were shown by Mr. Crane. The orthodox approach to legal causation is to view it as a chain. If authority is wanted for that rather mundane proposition, and perhaps it's not, but you can find it in our bundles in because at E15298, where you can see in the judgment of Lord Clark at paragraph 75, confirmation that legal causation generally runs in chains, not in jigsaws or in parts of indivisible wholes. Now, my lords, I don't mean by saying that to oversimplify the causal inquiry. The chain of legal causation is picked out against the background of the net of factual causation in all its complexity. And it's that task of picking out the relevant chain which is ultimately accomplished with the use of the court's common sense. But the criterion to which the court applies its common sense is the words of the parties' agreement in a contract case, including an insurance case. The effect of the jigsaw and indivisible cause argument is the following. The effect is this. Square one is the insured peril defined in the policy, occurrences within 25 miles. Instead of going from there directly to the loss, as you might in any ordinary case, in this case, you climb up a causal ladder to a more remote cause, the pandemic. You then slide down a causal snake through the government reaction in order to reach the final destination of the loss. But in the whole journey, you don't go back to square one. The peril is treated as just a starting point, which has no linear relevance to the loss that you claim. And the effect of the jigsaw approach is stated in the FCA's respondents case in many places. One of them, where we can just see 2 points together, so it's convenient, is B10347 in the FCA's respondents case, where at paragraph 39, they say this, and we'll need to obviously turn the page in a moment. As to this question of construction, the court's primary findings were that the cover for the disease outbreak as a whole, and is not confined to interruption caused by the part of the outbreak which is inside the radius. Accordingly, there's cover for the disease if it has a local presence, and the radius qualifier is merely adjectival. So there's 2 points there that I want to draw out. First, the FCA invites the court to rewrite the clause so that it ensures outbreaks of notifiable disease. At other times, they go further and they suggest that the insured peril is simply disease, and the court sometimes refers to the insured peril as COVID-19. It's also transparent in the judgment that the effect of it is to rewrite the clause, and to see that in relation to Argenta, your lordships can look at C3, page 85, judgment paragraph 161. And your lordships look at paragraph 161. I'll paraphrase it if I may. They say, point 1, starting on the second line, the Argenta clause 4D does not mean what it actually says. Point 2, starting on the fourth line, instead it means something different. And point 3, this does no violence to the language used. Now, with all respect, their lordships protest too much. Violence to the language is precisely what they have done by that form of reasoning. If a clause did purport to ensure an outbreak or a disease, that word would obviously require definition, because as Mr. Crane reminded you, not all notifiable diseases are brand new pandemics where we know exactly when they started and what a response is a response to. Many diseases have been around for centuries and they wax and wane at varying speeds. As you've seen already at E588, mumps and measles are among notifiable diseases, and the policy has to apply equally to them as it does to COVID-19. And in fact, as you've seen, Argenta 1 does not purport to insure against outbreaks, and it does not purport to insure against diseases. It only purports to insure against occurrence of notifiable diseases within a particular radius. The FCA's emphasis that such, my Lord Legate has a point.
Are you suggesting, Mr. Salcedo, that it's necessary to prove a causal link for the policy to apply between a particular individual case and the interruption of the business? Surely there can be a set of cases, even on your construction. Wouldn't you accept that there could be 50 occurrences of a disease which causes an interruption, and you don't have to show that each is separately and discreetly a cause?
Yes, absolutely right, my lord. I do accept that, and as I mentioned earlier, that's where the FCA treat this as if at that point as if it's a concession that we're ensuring outbreaks. But and I hope I dealt with that by submitting that the fact that we accept that if there are 50 outbreaks within 25-mile radius, the question then will be, after that date, what did those 50 outbreaks cause? Does not mean that we accept that we are ensuring in general an outbreak consisting of those 50 plus another 100,000 from somewhere else. And that's the distinction between the two cases. But yes, if I spoke as if I was suggesting that there had to be an individual causal chain from each one, then I didn't mean that. But of course, it does depend. It may be relevant to the date on which any claim starts from. If an interruption is claimed from a certain date, it's the cases up to that date that have to cause the interruption. There may be more cases at a later date. There may be different cases at a later date. But I certainly accept it's that group of occurrences within the 25 miles which are the insured peril and from which a causal chain must be picked out to loss. Now, given that the Argenta policy does not purport to ensure outbreaks or diseases, your lordships might expect to find something in the judgment or in the FCA's written case to deal with the point of language as to how, as a matter of language, peril 4D could be understood to mean that there's cover for the effects of an outbreak as far as the borders of the UK, or maybe it's England and Wales, or maybe it's England, I'm not sure what national means, but no further. The only linguistic point made in the judgment to support this is at C385, paragraph 160. And in the first sentence of 160, their lordship said, critical here again is the fact that extension 4D does not say any occurrence of a notifiable human disease only within a radius of 25 miles of the premises, or anything which dictates such a reading. My lords, there's the obvious point that what's missing is generally treated to be quite a weak argument of construction. But leaving that aside, there are four reasons, at least, four main reasons I'd like to put forward as to why that proposition makes no sense. First, the word only is implicit in every definition of an insured peril. If damage caused by fire is insured by Clause X, it's only such damage which is insured by Clause X. Secondly, adding the word only where the court would have it added seems to mean that the disease itself must not spread outside the 25 miles in order to remain a peril. But we've never suggested the fact that the disease or a given outbreak may include occurrences outside the radius is an answer to a claim. The suggested wording by the court, therefore, would impose a restriction for which we've never contended. And thirdly, the word only is equally missing from QBE 2 and 3, where its absence did not concern the court. And the same point might be made while I'm on this about any of the alleged anomalies or the indivisible cause point altogether, as we point out in our written case at paragraph 94.2. The fact that QBE 2 and 3 can be read sensibly, free of those concerns, shows that those concerns are not decisive in a way that would require Argenta 1 to be read contrary to its express terms. And fourth, the word only is not found in any of the other Argenta BI extensions either. As I showed your lordships earlier, peril 4B, for example, at C5317 is syntactically identical to 4D. In our written case at paragraph 74.3, we made the point that the judgment below would imply that 4B, which you remember is cases at the premises or attributable to food and drink supplied from the premises, that clause would cover any loss from the pandemic, which is even more extraordinary than the result reached in relation to 4D. As Mr. Crane mentioned, the FCA's response to that point is in their written case at B10394 at paragraph 194. And what the FCA say in paragraph 194, in the last sentence of that paragraph, is the clause envisages measures directed specifically at the premises to stop repetition or spread, measures that would not be taken on a national or wide area basis. The fortuity is therefore as a matter of construction, contemplating and limited to the at the premises aspect of any disease, not a wider outbreak. So they concede that 4B is limited. They then attempt at paragraph 195 to distinguish 4D. And the only point they make in paragraph 195 is that 25 miles is further away and suggests a wider outbreak and potentially more responsive measures than the words at the premises. Now, my lords, that's true, of course. The question, though, is how much wider? And the answer is given in the question. It's precisely 25 miles wider. The FCA does not and cannot point to anything in the wording of peril 4D that would assist a reasonable reader to understand that the phrase within a radius of 25 miles is in their term adjectival and thus plays a quite different role to the words at the premises in 4B. And my lords, I've got a couple more things to say about adjectival, but I see the time and I wonder if your lordships would prefer to take a break now.
Yes, thank you, Mr. Salzito. We'll adjourn now and resume at 2 o'clock. Thank you.
Thank you.